And I briefly just want to go over who we're talking with. So today we have Lee and Jonathan, who are both labor lawyers. But I just wanted to say that they came here not to necessarily provide legal advice, but to basically provide labor education about the tentative agreement. So just quickly, Lee Adler is a faculty at Cornell with more than 40 years of experience in labor law. He's mostly worked with firefighters and miners, and then giving education to both in the past to Columbia and now us here at the UC. And then we have Jonathan Siegel, who has spent over 30 years experience in labor law. He's had a full range of cases from individual jury trials to class action to arbitration and administrative hearings. So he's done a full range. And so we're really appreciative to both have Lee and Jonathan here. So just kind of the organization today is we're going to go over a couple just general questions. And then this is also a Q&A. So if students would like to provide any questions, please just write your question in the chat or say stack or write stack, and then we can call on you to ask your question. So briefly, let me just, before we get into the questions, the whole point of...
I just want to say hello to Elena Kay. I haven't seen her for a little bit.
Oh yeah, Alina, is she in? Oh, great.
Hello. Hi, nice to meet you. Nice to see you again.
All right. Okay, so before we start some questions, basically today's discussion, the goal is just to get some more transparency around the tentative agreement and what can happen with a yes and no vote, and just kind of the legal implications of that. I just want to be very transparent. So I personally voted no on the contract, and I know that
the voting's going on right now. Oh, that was one question I had. Okay.
Yeah, it ends on Friday. So I just want to be completely transparent about my stance. I know that some people here may have voted yes or are on the fence, and so I just want to this is a free space for anyone to come and ask questions. The whole point of this is just to get more knowledge around the tentative agreement from a legal expert's perspective. So anyway, yeah, that's it. I guess we can start asking questions. So let me go down. So briefly,
can I ask a question before?
Oh yeah, sure.
Elena T. In the Columbia event, for everybody who is listening in, the UAW came out with a tentative agreement for the graduate students there. I guess that was about a year and a half ago. I'm real bad at looking back in time, but it was a while back. But as soon as it came out, they did not offer a meeting to explain to the entire body at Columbia, which is much, much smaller than you folks, to say the least. But they didn't offer that at all. And then they just submitted the matter for ratification.
Oh, interesting.
And have they convened an event for the folks in the bargaining units that are still outside, to explain the contract? Like, I guess Jonathan and I will at least attempt to answer people's questions, but did the UAW offer that to the units that were still outside? Because it seems like it's awful quick that you're already in this ratification mode, and I just wonder about that.
Yeah, there were some town halls that were, or meetings or Q&A sessions that were scheduled for UCSF. It's a little bit complicated. There was an email shared last night in the organizing committee Slack that indicated that even though these town halls did happen, our own bargaining team rep wrote that apparently behind the scenes UAW encouraged not to advertise this because they were worried it would give us a platform. To be clear, this email came from a yes voter. So I don't want to get into that drama too much.
Okay, okay.
Town hall did technically happen, though it was not widely advertised. And I hope that we are going to be working through that at UCSF in the coming days about what's going on with UAW staff on our campus.
Okay,
Yeah.
okay. I'm sorry if that was an irrelevant question, but I was just curious about that, you know.
Yeah,
Yeah.
that's a fair question.
Because I was
to
a little
ask.
surprised to hear you say, oh, we're already voting, you know, kind of thing.
Yeah.
I'm also surprised to hear myself say we're voting, unfortunately. It was very surprising. They sent us home from the picket line on a winter break, and all of a sudden, the week of Christmas, we're voting. I was pretty surprised.
We just received a message in the chat that from Megan Olive, bargaining team has been having town halls throughout the duration of the strike, including before the tentative agreement passed. I think I don't think we're saying that we didn't have town halls. I think Alina's point based on the email was that we had town halls, they just weren't easily accessible to everyone. And I know each program had their own kind of town hall where they went back to the program graduate students and explained the contract. So I know that that has definitely happened. But again, it is confusing because we don't know the legal terminology. So it is difficult to determine whether this contract will benefit us or not. And so that's why we're just having this very transparent conversation.
Yeah, I think also, in large part, I think membership understands or was able to some extent break down what's in the contract. We sent out a lot of explainers. I don't know if people have read them. I think one of the other questions is like, what happens at the bargaining table, or a judgment on, like a legal judgment on how likely is it that we win this grievance, or like how common is it to go to impasse? What are the things that prevent that? And because we don't have access to like a lawyer directly, usually it's membership has to sort of rely on kind of word of mouth without being able to talk directly to lawyers and get these questions answered. So I think that's where today might lie.
Hey, George, can you, yeah, thank you. Appreciate it. Okay. Anyway, so I know we have a little bit of time. Okay, let's start with the questions and then we can have more of a discussion if that's okay. Yeah, okay. So let's start with just, this is an overall question. So what is kind of the normal process when a tentative agreement is ratified? And what happens if a tentative agreement is voted down? We just wanted to kind of hear your perspective on, we had some ULPs filed against the UC. Would those be maintained, or would, if we basically voted it down, would those ULPs basically stay, or would we not have them? If we could talk a little bit about that.
Jonathan, you want to go first? And
Sure. I mean, the normal process, if the contract is approved,
Okay,
would be that the UAW would notify UC that it was ratified. And at that point, you have a legally binding agreement. So it's in
Okay.
effect. And in that agreement are the obligations to withdraw the ULPs. So if it's not approved, and I think Lee actually had it just spot on correct in his email this morning, if it's not approved, then the ULPs are not withdrawn, because they are contingent on there being a contract. I mean, that's they're a tentative agreement, just like everything else that's a tentative agreement, the agreement to withdraw the ULPs. So if it's voted down, there's no agreement, and therefore they're not withdrawn. I mean, I'm sure the UAW, I'm reasonably sure that they haven't withdrawn them yet, and they won't withdraw them until there's an agreement. But there will be, once there's an approval and UC is notified legally, that's it. You have a contract, and the obligations that come from the contract, follow.
okay.
Agreed to everything Jonathan said.
Great. So I guess the concern for, thank you.
What a
No,
I
I'm
guess-
clapping to Jonathan, that's all.
What a relief. No.
You know, we're
Great.
a goofy duo. We're a goofy duo. I'm sorry.
I'm I guess the follow-up question to that is, I know it's a concern. For some students, we're concerned that if we vote no on the contract, there is a chance potentially to go to impasse. But if we still have these ULPs, can they go to impasse? And then also, if you could, I know a lot of students are not clear about what impasse is. If you could briefly explain what is impasse, and then if we would go to impasse ultimately.
Okay. Can I try this, Jonathan? And then I think I'm going to need a little help from you on this as well. So impasse is a concept that has a lot of significance to it. If it's real, meaning if in fact PERB finds there to be impasse. The University of California system can declare an impasse or seek to declare an impasse, but it's a little bit of a process, if I'm not mistaken, and that at that moment, part of the consideration of whether their belief, meaning UC's belief that there is an impasse, has to do with the fact that up until then, both sides have bargained more or less in good faith, and that both sides really or I should say at least one side believes that it's not likely that further bargaining is going to help at this point. And so we need to have some other parts of the California law to kick in to shape what goes on from impasse forward. And but if I'm not mistaken, their ability, UC's ability to go forward at impasse and then go on to fact-finding, et cetera, requires that they have a pretty clean record as far as ULPs especially. And that's where there's a dynamic where your side's challenges to the way UC has bargained, and in particular provided you information or not. And the issue about information and ULPs is that it's real simple. It's like you need the information so that you can make intelligent decisions about where to position yourself in all the different issues in contest between you and UC. And so at that point, the PERB people can actually, meaning the official governmental agency, can say, wait a second, I don't think this is an impasse because there's too much trouble that's happened prior to this declaration of impasse, meaning all of your ULPs. And therefore, we're going to say, I don't think this is impasse at this point. I'm not sure if they would jump in right then to deal with the ULPs or not, but it would certainly make the UC's impasse declaration not enforceable, if you will. And then at a minimum, and if it turns out that it's truly not enforceable by further PERB action, then you're just back to bargaining, including the possibility of getting somebody maybe different than Mr. Steinberg as a voluntary mediator at that point, as opposed to something further. But Johnny, what do you think about those things?
Well, I think it's a little bit, I agree with what you said, but I think it's a little murky for a couple of reasons. One is, just to step back, the way the impasse procedure works, okay, so one or both sides declare impasse, and both sides could. The first step is, if requested, they appoint a mediator, a different mediator than Steinberg. The PERB appoints a mediator, and that mediator goes forward for a period of time. And if that mediator says, like, I can't get it done, then there's a possibility if either side requests of a fact-finding panel of 3 people, one appointed by each side and one appointed by PERB. And so there's that process. And sitting alongside it, and not to get too lawyery, but these unfair practices, two things about them I would emphasize. One is they don't actually belong to you, the workers. They belong to the UAW.
Yeah, very important.
So the UAW can, for example, say, notwithstanding these ULPs or UPs, we want to go into the impasse process. We want the PERB to appoint a mediator. They can essentially, because I think the PERB, the first thing they would do if either side declares impasse would be to ask the other side's position. And, whether they think they can go forward and appoint a mediator or not. So I think the role of the UAW is going to be critical if you get there. They could say, we're gonna litigate these unfair practices, but in the meantime, we're not unhappy with an impasse declaration. We don't object to the appointment of a mediator, whatever. So a lot of this is going to sit under the control of the UAW. That's the thing I want to emphasize. I think that's important because, litigating unfair practices, the PERB is not going to decide the unfair practices in the next month. Because what happens is a complaint issues, there's a trial before an administrative law judge. The administrative law judge issues a decision that can get appealed to the full PERB, and then that decision can get appealed into the California court system. So the final resolution of the unfair practices, not to be a downer, that can take years. So I don't necessarily think that the PERB is good. PERB may look at it and make a determination whether they're in agreement with appointing a mediator or appointing a fact-finding panel, but they're not going to do the final resolution of these unfair practices for a long time. So I think all of that is by way of saying, I do think what the next process will be contingent on both the UC and the UAW and what they want to happen. And the other point is, which I saw someone asked, yes, they can keep bargaining. They can keep bargaining. If you turn the contract down, they can keep bargaining until there's a contract, no matter what's going on with the UPs, no matter what's going on with the PERB. And in fact, the statute even says that they can supersede the mediation provisions of the statute with their own agreement on a mediator. They could bring Steinberg back. They could bring someone else in. So there's, it's hard to give you a prediction of what's going to happen, really. But I would say that from your perspective, the driving seat will be occupied by UAW. I don't know if that's helpful or not, or too complicated.
Yeah,
but
I think it's very, thank you, Jonathan. That's
helpful.
such an important additional perspective about the whole impasse situation.
Yeah. That was really helpful. I actually did not realize, or it did not occur to me that UAW will be responsible for litigation and therefore can choose to bypass that and just engage in impasse. One question I have is that while ULPs can take time to resolve, PERB has to make a decision on whether or not UC or UAW has a valid claim of impasse. Is that correct?
Yes.
yes.
So do they make that decision basically based on like the number and quality of the RFIs and ULPs that are outstanding without deciding them? Or how do they make that decision if they're not making a decision on the practices and RFIs themselves, but have to make a decision on whether or not impasse is valid? Does that make sense?
Totally.
It's a very good question.
I think the answer is that they would ask for briefing from both sides to address that very question. And I think they would then decide, whether to allow the UPs to sort of go forward on their own separate legal track, but invoke the impasse procedure or not. I mean, so and I'm not, this is not, honestly, it's not anything I've ever dealt with, but I think that they can't sit back and wait for the UPs to reach their final decision because that could take years. So I think they would make a judgment based on the briefing of the parties, whether or not the unfairs appear to be serious enough to impact the impasse, declaration.
Okay.
Yeah, and Jonathan, and this is more in the form of a question, but so far we've said that that one of the things that I think a lot of the rank and file has been thinking of is, well, we've got these ULPs out there. They're pretty strong. They're pretty noticeable. And at least according to some of the legal people, that the ULPs could impact whether PERB actually declares an impasse. Okay. But the question that Elena Kay just wrote was like right to the real granular level. Well, okay. So what does it look like after there's a declaration of impasse, whether it's valid or not? You know, how does that, how does PERB decide the impact or the lack of impact of your 30-some ULPs or UPs? And I agree with Jonathan that the UAW is going to really be in the driver's seat about, quote, everybody's position, all 17,000 of you, not the rank and file. But, and this is where my question is, and I just wanted to say all those things to all the folks who are listening. Jonathan, do you think that at that point, that if they do ask for briefs to say, okay, so what is the meaning of these ULPs versus UC's desire to go forward with impasse? And they brief the issue. Could not the rank and file at that point hire counsel or retain counsel or something and file an amicus brief of some sort?
So intervene in that?
Yeah, to intervene. Or at least intervene with regard to amicus, if not be able to otherwise intervene.
I mean, it sounds like this is really uncharted territory for me. I've never seen that, but I suspect
Me too. So
I suspect they could. I mean, I suspect the PERB would want to make a showing of listening to everybody. And so if an organized group represented or by counsel or not represented by counsel, sort of popped up and said, wait, we want to be heard on this, I suspect the PERB would say, fine, file a brief. We're happy to read it. I mean, I don't know that for a fact, but my gut reaction is that PERB is gonna want to do that and appear to be fair. So yeah, I think so.
In my gut, which is even less sophisticated than Jonathan's, being outside of California, but if I'm not mistaken, the National Labor Relations Board, not to suggest that anything they do is something that PERB has to follow. Generally speaking, when you get into some delicate political issues, they're kind of open to hearing from a number of parties, that have some logical or relevant reason to want to have their voice heard. So that's what drives me, but I don't have it, in my fist to say, yeah, kind of thing. That's why I
would imagine, what I've done sometimes with the NLRB, and I would imagine you could do if you had a represented group, was asked to meet with the general counsel. You can go, besides a brief, I've had experience where I've gone and met with the general counsel of the NLRB in Washington and kind of pitched them my view of things. So I suspect they would want to at least appear to be open to all sides. I agree.
So I'm just going to jump in here real quick to talk about this briefing idea to PERB, right? And I'm wondering if we could.
The what idea with PERB, Elena Kay?
The briefing idea, that is that
okay.
ULPs and requests for information, which for folks who are on the call, requests for information are requests for information that our bargaining team makes that says, we need this information in order to make a proposal or decision. And if we don't have this information, then we are sort of not bargaining on good terms. So often PERB says, if you have not answered these outstanding RFIs, you have failed to bargain in good faith, in this case, the UC, which would prevent a finding of impasse. And so my question then is, I want to talk really briefly about some of the RFIs that we still have outstanding, and kind of basically do like a very brief briefing of you all and kind of talk through how PERB might receive that. And then if it's not useful, we can skip past it. But the RFIs that we have outstanding is we don't have UC ship costs. We don't have retirement plan info. We don't have info on the gender, race, ethnicity, national origin. Perhaps most importantly, we don't have historical pay rates for any of the universities. We have off-scale pay rates for every campus, or sorry, for UC San Diego, UC Santa Barbara, and UC Riverside, or sorry, UC Berkeley and Riverside. And we don't really have any information from UC on moving relocation reimbursement, the history of travel reimbursement. So essentially, I think the point that I would be making is that we have significant information missing on the history of wages at almost every campus, on the history of retirement plans, on the history of our health insurance costs, on the history of off-scale pay raises, on the history of how salaries determined. How reasonable of an argument to perp is it that this is an example of the UC failing to bargain in good faith, because even on wages and insurance and these economic things, they have failed to share, information about what historically has been done across the UC campuses. And so our bargaining team has not had that information at the table.
Well, part of it is going to be what your bargaining team says. I mean, remember, your bargaining team reached a tentative agreement. So they didn't take the position, we can't reach an agreement on this subject or that subject without this information. They actually reached an agreement. So I think that's going to really cut against you, honestly, because it requires the UAW to say kind of two contradictory things, which is, because of this information, we couldn't reach an agreement. And oh, by the way, we did reach an agreement. See, that goes back to what I said about the UAW. I think it's hard for you all to make that argument if the UAW is not making that argument.
So if we kind of swept the bargaining team and had a new bargaining team after a no vote, which also allows us to reinstate the RFIs and ULPs, would those RFIs and ULPs still be something that we can use? Or would PERB say, well, you undercut your own argument with this previous bargaining team?
That would be a better position for you to be in, for sure.
It's crazy about this, and Jonathan, correct me if I'm wrong, is that short of just a no vote, it's almost like the rank and file is just not in a great position unless you can generate a no vote. Because if you can generate a no vote, it can push back on some of these things. And Jonathan, correct me strategically if I'm speaking accurately or not. The no vote would sort of like resonate all over and permit the possibility of a new bargaining team, a whole bunch of stuff. But without the no vote, the particular way that labor law works keeps putting the UAW in the driver's seat to make decisions about things that you need them to decide differently than the way you're feeling right now.
Well, and clearly without a no vote, you have a contract and all these charges are withdrawn. I mean,
Yeah.
It's kind of the end of the road without a no vote. Not kind of, it is the end of the road.
Yeah.
I'm really loving this thread of questions, but we have a list of questions we'd love to ask you. And then we
Please.
want to break into Q&A before 10.
Yeah, thank you, Asa. Do you want me to finish up the question? Yeah, I can guess.
Yeah, go for it. Thank you.
Just briefly, I want to talk about Daryl Steinberg and then talk more specifically about wages and the grievance process. So my first question is, we have been in voluntary mediation with Daryl Steinberg, and it sounds like according to the bargaining team, they have said that Daryl Steinberg has said or suggested that he will not continue mediation if we turn down the contract. And then if that were the case, would we then have to bargain with a new mediator, or would we just not have a mediator? How does that work? Is he even allowed to step away? I don't really know legally if that's, what the implications are of that, but if you could explain that a little bit, that would be great.
Mr. Siegel knows a little bit about Mr. Steinberg, so.
The answer is yes, he can step away.
Okay.
We don't know, I don't know anything, maybe y'all do, but whether this is just a big bluff as a way of putting pressure on you. In fact, if you voted no, whether he in fact, I mean, they want a deal. Look, the UC wants a deal, the UAW does, the governor does. Steinberg is one of the instruments for that. So whether he would really step away is who knows, or whether he's just putting pressure on you. I don't think it's, but if he did, you still have the right to bargain. If you turn down the agreement, no matter what happens, if you turn down the agreement, you have the right to continue bargaining. And whether it's with him as a mediator or with no mediator or with a new mediator, that's what could happen. And no one, there's a part of me that feels, from my very distant perspective on this situation, that it's a pressure tactic. To me, that's how I read it. But whether or not, I don't know how much in love with Darrell Steinberg you are anyway. So if he steps away, he steps away. I wouldn't get hung up on it, is I guess what I'd say.
Yeah, and the other thing is the key word is instrument. Newsom, who is really, ultimately able to call almost any shot that he wants because he could replenish UC in some way, he could, et cetera. He needs a deal. He needs a deal. And if his instrument didn't work the first time, it might work the second time after a no vote. So yeah, there's no reason to get hung up on him. But basically, if you vote no, there's all kinds of things that can happen that aren't bad for the rank and file.
Okay,
But you have to vote no.
I see.
What is Darrell's vibe, I guess? Can we talk really quickly about that? Like, what
we
is
don't have much time. I really want to get through the next couple of questions. We have just 23 minutes.
Okay.
Like if you have a question, just please stack.
Yeah, we'll come back to that if that's okay. So I briefly just want to talk about wages. So this year, this is maybe I think only UCSF specific. I'm not sure if this is true with other UCs, but at the beginning of our school year, we received a $2,000 bonus this year due to inflation. Our wages in the tentative agreement are calculated without the $2,000 bonus. We were basically told by the bargaining team that after the tentative agreement is ratified, we would file a grievance for the $2,000 in hopes that we would get that bonus basically every year. How does that grievance process, we just want to know, like, how does this grievance process work? Is it likely to be approved from your experience? Because they're kind of, it sounds like that they're betting on that we will get this $2,000 per year, but if we don't get this $2,000 bonus, it will ultimately be, we would get lower wages than we would without a contract. That's kind of the issue that I see here. And so I just want to make sure, like, what's the likelihood of getting this $2,000 bonus through the grievance process?
I'll speak briefly first. If the bonus is in the contract or somehow can be read to be in your contract from the language of the bonus, then it's something you can grieve over. But if it's not in the contract, mostly, and I haven't looked at your grievance procedure, but most grievance procedures say that you can grieve over matters that are disagreements between the parties. So maybe you can grieve over it, but I don't think it's a very likely positive result, because if it were, it would be included in the TA. And that's my view. Johnny, I don't know what
I tried to figure this out last night, and
oh, you did? Okay, we tried to figure it out. We couldn't figure it out,
there's a provision in the tentative agreement that keeps alive all past practices, including past practices related to wages. So I think essentially the way I saw it was that this would be a question of whether or not this bonus is a bona fide enforceable past practice, right? There you go. Thank you. So I don't know the answer to that, because I don't know the circumstances of how it was given, what was agreed with the union, if anything, what you all were told. And I don't know if it's been brought up at the bargaining table, because that's a very significant factor in determining whether something is an enforceable past practice. Did it come up at the bargaining table, and was it rejected by UC? there's a lot of facts that I don't know, but I totally agree with Lee that if it was really good, it would the easiest way to solve this problem would have been to put it right in the TA, to just say that. And so I think going to grievance, you're going to ask an arbitrator to decide whether it's an enforceable past practice. And I'm sure Lee teaches classes on this. There's all sorts of things that go into whether that's something is an enforceable past practice. I don't know the facts for this case, but clearly the safer thing would have been to just put it in the contract. That's all I can tell you.
So
I see.
can I ask
One
a-
time, and by the way, just for better or for worse, one example of something that is given by management to labor or by the employer to the employees rarely constitutes a past practice.
That's what I was thinking. But I don't want to give an opinion on it because I don't know enough, but I wouldn't feel from what I've heard that it's any guarantee.
Yeah, that's what we've been saying to each other.
Elena, do you mind if I ask a clarification?
Yes, but I would also like to ask a clarification because
You
I'm
go
looking at-
first.
Yeah, so UCSF has known to do top-ups in past practice, and so I think the idea is that because we have top-ups, that we can claim the $2,000 as part of it. I don't know if that's true because we've had a different type. We've had, I think, less than that as a top-up. So, yeah.
I don't know enough, but I would say this: if they're saying you're going to go to grievance, the assumption is that UC is going to oppose giving it to you, right? I mean, that's what a grievance is. It's a
Yeah.
dispute. You say I'm entitled, and they say no, you're not. So UC must have some argument they think they're going to make as to why you're not, unless it hasn't come up in bargaining at all.
Yeah. Okay. Alina, if you want to ask your direct response, and then we're going to go to stack. Oh, I think you're muted.
Yeah, I just wanted to clarify. I actually interpreted bargaining team's argument slightly differently because the top-ups thing seems less likely since we, for example, at UCSF are going to end up getting on scale anyways in October. But I think the argument here that I as I understood it was that practices related to wages, hours, etc., that are not in conflict with this agreement shall remain in effect. And the argument I heard being made was that $2,000 supplement we received was separate from wages. And so therefore not going to be in conflict with our wage agreement. And that's why we will be allowed to grieve it. Is that a reasonable argument that $2,000 is not a wage, it's a supplement? How do you all feel?
Doesn't work for me.
I mean, it still comes down to whether you're entitled to it, no matter what label you put on it. Whether the fact that they gave it to you once means they have to give it to you again. And, and I don't know what they said when they gave it to you. Did they say this is a one-time non-precedental thing, or I don't know?
Yes, our email said one-time payment.
Yeah. It was a one-time payment, and they said it was because of inflation, due to inflation. So I guess UC could claim that, oh, we're not, I mean, there's always inflation, right? But maybe it's not as severe, so we don't need it. I'm not sure. Okay.
Well, those words, a one-time payment for, yeah, it just strengthens my feeling, Elena T. and colleagues, that I'm not sure that you should count on anything like this working out okay for you all. This particular thing.
I see. Okay, so it's pretty much, yeah, I was just gonna say, it seems like this might be more of a risk than like a certainty. Okay, so unless anyone has a direct response, I would like to go to stack, if that's okay. Yep. Okay, so let's, Asa, do you want to take it away?
Sure.
Yeah.
The first stack was Madison. I hope I'm pronouncing this right. I'm so sorry. Sato. I don't know if you want me to read your question out loud, if you'd like to talk to the group yourself.
I can just read it. If the contract is voted down and we continue bargaining, which articles would get un-TA'd? is there a standard to which proposals we go back to? And would all mediation derived TAs be off the table?
I don't know about the second part of the question, but if you vote no, the TA, whatever was TA'd is what was voted no or voted down. And I think nothing would survive, meaning nothing that was TA'd would survive if you vote no on ratification. Is that accurate, Jonathan?
I mean, I think what would happen if you voted no and the UAW therefore took your message back to UC would be something like, well, we continue to agree with all the TAs except, and it would probably be wages and some other things like that. I don't necessarily think everything goes back to stage one. I think the parties could agree that 90% of it stays the way it is. But
Oh, yeah. Yes.
you know, but what they would need to do then is identify what it is they think they need to change to get a yes vote. And I don't know, you all know the issues. I'm assuming it's a lot of it's wages. So like, I know there's these issues around international students. I mean, I think the UAW would have to then drill down into what provisions they wanted to go back and fight on based on the pressure that's put on them. I mean, I wouldn't think the whole thing would get undone.
I mean, Lee, I think you were involved in the Columbia kind of stuff. They went back and they reopened 4 articles, I think, right? Wages, dental insurance, third-party arbitration, and sexual harassment grievance process in parallel to the Title IX process, and kept everything else. I think that's like the sort of the most likely scenario, right? Is that UAW hears what articles need to be opened for membership to vote yes on, and then we renegotiate those articles.
Yeah, I'm sorry, I spoke incorrectly. What you and Jonathan did, in clarifying, what I was saying is that if what I was thinking, which was not careful enough, was that theoretically you could reject everything, but it with the no vote, meaning starting over. But practically speaking, there's no real, and I think that's what you and Jonathan are both saying, and what the Columbia folks did is that there's really no reason for that. It's just to try to locate or identify the things that caused the no vote. And then that, of course, opens up a lot more dialogue between the rank and file and the UAW at that point too, if possible. So, but I agree with both your 2 observations rather than my blanket observation for our colleagues.
Great. So next question on the stack, I suppose. We have, how do you pronounce this? Saya?
Yeah, Saya. Hi.
Thank you. Sorry about that. Saya. Oh, would you like to say your question? I can read it for you if you'd like. If the contract is voted down and we reopen everything, would it be considered regressive bargaining for them to offer a worse proposal, considering it was all in all the packages before? And then second question, it would still at least be bad faith bargaining to offer worse proposals after the membership clearly voted no, was the second question.
Sorry. My headphones make me drop Zoom calls. Should I
So
ask?
would you like to ask a question? Sorry.
Yeah. So my question was that, say SRU votes down the TA and goes back to bargaining, and all of the proposals had been given from the UC in packages, and they would reopen those packages. If the UC were to offer worse, like wages, for example, or something like that, I assumed it wouldn't be considered regressive bargaining because it's like packages or something, but it would be considered bad faith bargaining still, because obviously the membership voted no, so why would they like it would be bad faith for them to offer even worse. Is that like a correct understanding of how that would work?
I'll let Jonathan answer that first.
Yeah, no, I think you're right. And I think that, though I think Lee actually, I don't know who Lee's email this morning went to, but Lee addressed it, I think I agreed with is, if they're going to move backwards on anything, they're going to need a really factual legal justification for doing it. If it's just to put heat on you, I think it would be considered bad faith bargaining. I think if there's something like, I don't know, they took money out of place A and put it in place B, it's conceivable you could imagine a situation where they could justify it, but they would have to justify it factually and legally. They can't just do it, to punish you or to put heat on you or something. Which I think is what Lee said this morning. Did I read that right?
Yeah. I think that's right. And I'm sorry, Saia, I wasn't, or I'm not familiar with the way you spoke about all these different packages, et cetera. But I think Jonathan's comment about moving money from here to there, it could legitimate what appears to the rank and file as worse offers, but those explanations would have to be credible and convincing, or else they might well fall into either regressive bargaining or bad faith bargaining.
Can I clarify, is there a difference between regressive and bad faith bargaining?
I mean, regressive is kind of a subset of bad faith.
Yeah, that's what I thought. I didn't know it because in New York, it would be, we don't use that term in the public sector. It's bad faith bargaining. I think what Jonathan said is what my intuition tells me.
It's just a way of describing a particular kind of bad faith bargaining.
Yes.
I don't know if if you wanted to clarify the thing about packages or.
I don't know if I have enough clarity on it myself, but what I was told was that because the UC was offering things and not actually putting things on like paper in a way so that they could always come back and edit it or change things without it being considered regressive bargaining. And after, if a TA is voted down, it would just go back to like doing that. So it wouldn't necessarily constitute as regressive bargaining, I guess. I don't know if that makes sense.
Can I try to clarify?
Please, yeah.
Okay, so I think what Saya is saying is that well, in mediation, things were proposals. So as soon as they became written and signed, they became proposals, I think. We can talk about that in a second. But one thing is that some of the offers made before mediation were either supposals, so like non-binding, or in some cases, packaged. So for example, they'll give us an offer on wages and transit together. And so what we're told is that when things are packaged, you can undo them, but when you make an offer on a single article, you cannot undo them. Is that correct? Actually, first of all.
I don't know about that.
I mean, it's a way to bargain. I think you can bargain that way if you want, I guess. We'll do ABC if you do DEF, right? That's sometimes happens.
Okay.
But if you're not willing to do all of ABC or DEF, then we won't do ABC. I mean, bargaining is pretty free form. You can do what you want, really.
Okay. I think the argument was that packages prevent it from being regressive bargaining on either side. So either side feels comfortable undoing. But if you only put forth, let's say, $44,000 in wages, and then the university doesn't accept that, you can't come back and say 50,000 because that would constitute regressive bargaining. But if you had packaged it, you could later make an argument that's not regressive bargaining because it was packaged. That's what we've been told.
Cool. We got a related question from Megan.
So could we answer that just a small clarification about packages.
Oh,
Jonathan, excuse me, Asa, could I just ask Jonathan a quick question, please?
Yeah.
Jonathan, it seems to me like the concept of packaging qua packaging or packaging as sort of like stalling or halting a possible regressive or bad faith bargaining, it just doesn't strike me as logical or consistent with the principles that Herb and collective bargaining are about. I think they would still look into, and again, this is just my intuition that I'm asking Jonathan about it. I just don't think that packaging is the thing that solves the problem for UC with regard to bad faith or regressive bargaining. It's rather what actually are the changes in the package or in the separate, single proposal that will or will not constitute bad faith bargaining. And that's in the form of a question to you, Mr. Siegel.
I know, pardon me, please excuse me all, but I find this a little too abstract to really answer. I mean, I would need to know what had been proposed and what had been counter proposed. And then, because, the big question with bad faith bargaining is, are you genuinely trying to reach an agreement? That's what bad faith bargaining is, bargaining in a way without a sincere intent to genuinely reach an agreement. And so I guess I would feel like I'd need to know what was package A versus package B and how it changed. And I can't give a blanket answer. I'm sorry. Does that make any sense?
I hear
it's
that.
just too abstract for me.
Yeah. Well, yeah, and it may not be that important given, what other things are on other folks' mind, because that issue is probably not going to determine all that much about how people vote or don't vote, on a particular thing.
Okay, so to summarize, it would be bad faith bargaining to suddenly offer us a lot less on everything after a no vote.
Yes, I think that would be. And I don't think they would do that. I think, if you want my prediction, I think what they would do is just say, this is our final offer. I mean, I don't know that they'd go back on everything, but I don't know that they'd go forward either. I don't know the bargaining well enough. At some point, they just say, look, this is it. And then the evaluation has to be, well, did they bargain in good faith to get to that final endpoint?
Okay.
I'm good with
Sorry,
that.
Let's try to go, there's a few questions on stack. I want to give them enough time.
Yeah, and I could stay another 15 minutes. I don't mean to be putting it.
Okay, yeah, we
Jam
probably
everybody.
will need that. We have a lot of questions here. So quickly, let me go to stack. Megan Olive, if you could, do you want me to read your question or would you prefer to?
I can say it.
Okay, yeah, sounds great.
Yeah, so kind of following this theme, just in terms of what you think about UC not being likely to just like undo all of the TAs, which, as you said, is a possibility, but you're kind of relying on their acting in good faith. Do you think that's dependent on us maintaining the strength of the collective strike that we've had so far?
Is the question whether they would engage in bad faith bargaining if our strike is weak?
I think everything is dependent on you maintaining strength. Actually, I mean, to be honest with you, I think that's the key to everything. I don't know. What do you think, Lee?
Absolutely. And no vote. No vote and continued sustained pressure is the pathway, if there is a pathway, to gaining what you folks, those folks who are skeptical or going to vote no, that's the pathway. If either of those things drop off, then meaning sustained strength or a no vote. Well, no, if you don't succeed with the no vote, it doesn't matter. That's, as Jonathan said, that's the end of it all. You've got a contract then if you don't get a no vote. You've got the contract that the bargaining teams have obtained. If you vote no and you keep up the pressure, because that's what they did in Columbia. They not only voted no, but they just just the rank and file, just, like, wow, what they did after the no vote in terms of the kind of cohesion, the kind of strength horizontally, and then ultimately the pressure they put on the UAW, and they got some real changes as a result of that. And none of that would have occurred without a no vote, A, and none of that would have occurred without B, the pressure.
Yeah, and just to be clear, when I think about what might happen after a no vote in your strength, unless the worrying about they're going to just regress on everything, then are you going to get any progress out of it? If you vote no, are you going to be able to get UC to improve the offer? Is kind of the perspective I have on it. And it absolutely depends on your strength.
Okay, I have a quick response to that. So this is kind of the issue right now, like we're trying to figure out, do we have the strength, right? Like, are we going to be sustainable? And so that's kind of where the division lies right now. Some people are saying, yes, we're not, like, we don't have fewer people at the picket line. We're not going to maintain the strike. Others have said, hey, we're going to submit grades soon. We have power in, withholding grades, because in Columbia they did that. And also in Columbia, it seemed, so when I did a lot of reading on Columbia, it seemed like only a small percentage. It was like, was it 200 or something, roughly about 200 out of like 3,000 were actually participating in the strike and withheld grades. And that actually had a major impact towards the end. So I would like a little bit more clarity on that, Lee, if you could provide. So what does it mean to really, like, what is sustain, like, how much power do we really need? Because we haven't withheld grades yet. So yeah, I don't know if you could follow up on that. And I guess how important is really the picket line here? Because we are dwindling. It seems like in Columbia, it was dwindling too. So that's why I'm asking about it.
Yeah. Elena T, I only have bits and pieces of the actual story because my responsibilities were educational before the vote, and then it came down to no, and then I followed some stories in the paper, and then we also had a whole bunch of the principals address a class of mine this fall at the ILR school at Cornell, and they gave a lot more detail about the rank and file organizations. It's hard to say that everything. I'll just try to list 4 or 5 things, okay, Elena T, and then you can say what you might.
Sure.
One is that it's almost impossible to sustain the numbers on a picket line, even in the private sector. Sometimes it is, and sometimes it isn't. And that may or may not be dispositive of, an indicia of strength or something like that. What the students at Columbia had, I think that was so very valuable, was their horizontal way that, maybe there were only 10% of people that were quote unquote militant or most forceful or whatever you want to call it, and there was another 2,000 or so that weren't so forceful or so contributing. But what they did, and this was the brilliance, I think, of the men and women, the women and the men, I should say, at Columbia, was that they figured out different kinds of constructs, rank and file constructs that could be used to engage people where they would feel comfortable and where they would stay involved and where it could be somehow noticed that they would be involved. So they would maybe segment the whole academy in some ways and put, maybe 30 people in charge of different segments of the academy, and then have them check in certain ways with different people that would, what Richard Nixon would call the silent majority, but in terms, they were just silent in a certain way, but they were not silent in other ways. And so different people who historically had been sort of a little on the sidelines, but very open to the leadership, but not quite comfortable being, visible and militant, were able to locate a place where they could feel that they were part of things and with people, et cetera, et cetera, et cetera. And that was something that then other people made very noticeable to the bargaining teams. And the other thing that they did was that they recreated the bargaining team. And they made the bargaining team actually be more, if not almost entirely, accountable to the rank and file, as opposed to accountable to the UAW leadership, if you will. And so once that was done, and once people, again, the silent, the more, the great numbers of folks that I'm sure that is also true at UC, like 17,000 people, maybe 15,000 or so are more on the quiet side than on the militant side, if you will. But it was the idea of consistently developing hope by different kinds of horizontal organizations, with the ultimate success being the bargaining team. And so what they did was they created a structure that actually cohered and sort of like threaded the needle between the folks that had the most, if you will, the most leadership, militant, no vote position, and have people who were not, that far out there, in terms of their positions, had the great majority of people feel comfortable with them, meaning that there was sensibility that just kept moving back and forth between the real rank and file, kind of the quiet rank and file, and the more active or militant rank and file. So the lack of a strong picket line or this or that really was not that critical, because what was critical was that they built this fibrous, trusting relationship between each other. And that constituted the word strength, if you will, meaning, and so that strength eclipsed what might be other markers traditionally. Oh, it looks like we don't have much support anymore because there's only 3 people out today, or 4 people or something. Or it looks like, this because people, responded more, but they haven't. No, those things were pushed, that kind of doubt was pushed away. And what was elevated was the fact that people had these deeper, trusting relationships with each other. And that's what took the no vote from there, where it might not have, as Jonathan or somebody, I think Jonathan just said a few minutes ago, excuse me for speaking so long to this, but I think it's really important, is that, if you get the no vote and then you just kind of disappear in terms of the relationships, the strength, the kind of strengths that the Columbia folks, evidenced for us, they showed us how that could be. You're not going to get the UC to move, very hard, but the UC might well move if they start feeling a force that felt like what the force at Columbia felt to the trustees at Columbia, which are no slouches, I mean, if you think the UC people are big shots in the world of capital and, internationally, et cetera, believe me, the Columbia trustees can match them, in terms of their, boom, 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 at the top of things. But they were brought around because of what the rank and file structure looked like. Trusting relationships, respectful, trusting relationships that tried their very best to locate a place for all the different kinds of people that were in the bargaining unit. And that's a big chore, much bigger chore for you guys than it was in Columbia, just because of the numbers. But if you could pull off something like that, boom, I think things could change if there was a no vote.
Okay, I see. That makes sense. Okay, I know that we're kind of close to ending here. I see that there's 2 more questions, so I'm going to go quickly through Andrew's. So he he said, would it be possible to talk about the legality of what many students at UCSF will end up doing with a no vote, which is engaging in a partial strike? Is it illegal or just indefensible? Quickly, Andrew, we have a document. We talked to Joe Block, who is a retired labor lawyer who basically answered these questions in detail. We will provide that document so you can refer to that. But briefly, from my understanding, and if Lee and Jonathan, you want to back this up or not, academics, or like us as graduate students, kind of have academics and we have employment. And it's kind of like a blurry line between the two. So I think it would be very difficult, from my understanding, for UC to file a UOP against us, because it's not completely clear what work that we're doing is technically part of our academic progression, which we're allowed to do, versus employment. I don't know if Lee or Jonathan, you want to answer that at all. But that is just a brief kind of overview. And then Joel went into more clarity on that, but
historically, Jonathan and I both have felt that partial strikes, quote unquote, if you say that's what you're doing, or if it's determined that's what you're doing, you're violating the law.
Right. I think,
and if people do things, that are below the horizon, or somebody wrote in, we've been partially striking all along. Well, maybe some people see it that way, but if it was ever determined that that's what you were doing, it would be immediately outside the law,
Yeah, Joel was saying that he felt there is California court precedents for UC avoiding clarifying the dual role. And so this idea that it's still kind of up in the air that our role as laborers and our student status are intertwined in such a way that partial striking is a very kind of difficult thing to apply a levy on us.
Yeah,
and he felt it was unlikely based on the court.
Asa, I'd agree with that. I don't know what Jonathan thinks about that, but I would agree that the blur that you're talking about, and the fact that UC has not brought it up, I thought, as about a week ago or week and a half ago, in bargaining, et cetera, that if there's de facto, meaning just as a matter of fact, people are sort of striking, or something like that, like that as a student, it's going to be tough for them inside the PERB with that.
Yeah.
UC, it'll be tough for UC to hurt you that way.
I think Joel is 100% correct that they don't want to go there. But it is technically, I mean, I wouldn't, from your perspective, I wouldn't be so unambiguously articulate about it. I wouldn't say.
Right. I agree.
I think the sort of idea is that we have stuff that we must do for 20 hours a week that is academic progress, and we only work 50% full-time equivalent, which is 20 hours a week. That is labor, right? And in practice, that might look like growing up some DNA, kind of getting it into some cells. And so it's like hard to distinguish between those two. And I think the flip side of that is UC has argued that we are these dual student employees. That's why they can say, oh, like you must make enough academic progress so we can give you a grade, et cetera. And so I think one of the other practical questions was that, like, if we are completely not doing any labor or making any academic progress, and our boss says, we're going to take you off this paper, right? What happens to that worker then in practice is that they get taken off this paper, and then maybe UAW files an unfair labor practice, and that is resolved in a year. Is that correct?
The paper.
Yeah, like that is the retaliation, like taking off a paper. Sorry, we publish papers. That is the main way we make progress.
Sure.
For future careers. So like a really big thing you could do is you could say, okay, you're not coming into lab at all, and I'm a PI. I hate labor. I hate everything that you're doing. I think you deserve to get paid nothing. And as a form of retaliation, I will remove you from this paper unless you come back to work. In that scenario, UAW hopefully gives a cease and desist letter to that PI, and then files an unfair labor practice. Correct?
Wouldn't there be something separate from any union representation that the student could do at that point?
Yeah, that's exactly what Joel said. Is that it becomes an
Oh,
academic.
okay. Well,
Yeah, no, that's correct.
yeah, and there could be a contradiction between the PI/professor and the what Jonathan said about the university and Joel saying, we don't want to go there, and I don't know what would happen, but there might be a practical solution to that as opposed to ULP or something like that, where the university might not want the PI to be behaving that way.
Correct.
I'm not sure, but I don't know if this would move towards a ULP as such, but I don't know, Jonathan, any thoughts?
Yeah, I mean, or it could be a grievance under the contract, or, but I think you're right. I think UC would be very unhappy about PIs making these kind of decisions on their own. And one of the things they're fearful of, one reason they don't want to go near this question is they don't want you to be ruled as 100% employee. It cuts both ways. I mean, then they're got to double your pay. So, I think that there are, especially in the case of the
I
I'm
think
sorry,
we
I
lost
couldn't-
Jonathan here, but
Yeah,
um,
but I think his answer
I
probably
think he's
allows us.
back.
Jonathan, are you back on?
Yeah, just I may we're doing this whole switch over today on our internet and blah blah blah. So I may just disappear at some point. So
Please don't disappear.
I mean, you have my cell phone, Lee. You can call me, but
Elena T, just for all folks, et cetera. I know that Jonathan has a zillion other things to do, but I got the things done that would allow me to be on at least till let's see, it's 10, is it 10:15 now or so?
Mhm.
Yeah, I mean, I could be on the call for another 45 minutes or so. If that's at all of any help to the folks that are on the call,
Yeah, I think if we can stay on for a little bit longer, I think that would be great.
Okay.
I think we
I'm
have
gonna
one
leave
more
at
question.
1:30 at 10:30. So I have
Okay,
Okay.
that would be really helpful. I think we answered the last question from, I don't know if anyone else has a direct response. If not,
missed one from a M Air Good. They just said stack. They didn't say a question.
Hi. Mark, and thank you for this this call. I'm actually a K-12 teacher in Oakland and have been on the bargaining team. I work with BAM Strike to Win caucus, and I really wanted to agree with the statements that have been made a few times that the starting point is a no vote. And it's been my experience in Oakland. We've gone to impasse a number of times. We've rejected TAs, that there's nothing to empower the rank and file membership like voting no against a tentative agreement. And it really does transform. I appreciate all the attempts to answer kind of legal questions in the future, but that strength of the rank and file really does transform your whole situation. I'll just say we've never come out of rejecting a TA in a worse position that we entered into it, and we've really come out better, overall. So I just wanted to make that point. Everything starts from a no vote, which I know has been said, but I really want to underline that. Thank you.
okay,
Cool.
we
Thank you.
appreciate it.
Thank you so much. That was great.
That seems like that was a statement. I don't know if we have one more question, because we want to make sure we end on time at 10:30.
okay.
So, who was the last? Okay, so we had, sorry, I think Alina was on stack. I don't know if you wanted to say anything more, unless, okay, Alina, yes, sorry. Yeah, you have.
Yeah, I'll read Saya's comment, and then I will then move on to the question that I had. Either way, legal protections from retaliation as well as legal precedent to declare it as illegal intermittent striking are thin compared to the protection we have in collective action in our union forcing the hand of the UC to protect our colleagues. I mean, it sounds like even if we were full, you know, no academic progress, not even crossing the building to go to the bathroom, that practically this is like an academic matter. It would take a pretty long time for PERB to resolve, if PERB even took it on. And that's not really where our protections from retaliation come from. But it also sounds like this is not a fight the UC would want to have, because if it's found that we are indeed employees, then which would make it partial striking, but then we would all get paid 100% FTE. So that's not really an argument that the UC can make at PERB. Is that a decent summary? Especially Jonathan, because you cut out.
Did I think that's totally accurate.
Okay, great.
Okay.
But if you are being retaliated in your lab, you should reach out to bargaining team so we can file a cease and desist and get this academic stuff started, because that's where our protections lie, is organizing around it and these cease and desist letters that put PIs on sort of the bad side of UC. So, and talk about it publicly, yeah. So one question that I had was about impasse and fact finding in this whole process. So one thing is kind of like that we are supposed to be afraid of impasse. And so we do have this graphic that we haven't really shared yet, but basically, you know, the first step is someone tries to declare impasse, could be UC. In the case of UPTE, it was UPTE themselves declared impasse. PERB, you know, evaluates these briefings, as we talked about earlier today, to determine whether yes, it is impasse, no, it is not impasse. Then you would get an unfair labor practice and go back to bargaining. And then I want to talk about the second step here of fact finding and there's this kind of idea that as soon as we've done the 15-day PERB mediation and that doesn't resolve with anything, and we go to fact finding, that everything is on hold. But my understanding is during this time, we can continue bargaining. And in fact, UPTE reached an agreement during that time. So in practice, fact finding is kind of this side process. And during it, we can just continue to bargain as we get more information. Is that a decent assessment?
I think you can keep bargaining.
Yeah. Yes.
Okay, great. All right, so we have 7 minutes. Does anyone have other questions?
I saw some direct responses. I don't know if you want to address them. I think when we were talking about kind of this idea of partial striking, or Andrew said something about it's not about just maintaining mouse colonies. It's picket leads saying that they're going into lab to do just collaborative work. It's students planning classes while receiving strike pay. I don't know if we want to talk about that a little bit more.
One bit that, you know, might just be, people have access to this information, but just so everyone hears it now, is that Joel was pretty positive, comfortable about the idea of maintaining academic progress. He felt that if you have an individual student who says, okay, I want to be a good student and I want to be a good member union, a union member. So I want to be striking, I want to be in solidarity, but I don't want to lose all of my academic progress. He personally felt that that was like a kind of a defensible position that you could keep going. He said he felt he had a hard time believing someone trying to stop you from being a good student. But of course, I think he saw more about like going to classes. But yeah, so I don't know what y'all think about that.
Yeah, I mean, I think this really comes down to the question of, is academic progress and being an employee two separate things? If they are, then this is not a partial strike. We are full striking our labor and continuing academic progress. If we are wrong, then we become 100% FTE employees, where our income becomes $88,000 to $90,000 per year.
Yeah, what Jonathan said a few
That's-
minutes ago is still true. You know, the messiness between employee and employer, it's not going to end up hurting. I don't think it's going to end up hurting the rank and file.
Okay, that's good to hear that clarification, because I know that that's been a concern for a lot of students. If the contract gets turned down. So, okay, other than that,
We just ask if that's clear for the people who asked it and give them a moment.
yeah, that's true. Yeah, let's ask for
Andrew?
if anyone has any follow-up regarding that, because we want to make sure that, all questions are heard.
Yeah, I think that's really clear. I was just a little concerned things like collaborative work seem a lot more like they could be assigned as work and not student experience. So those students would be more at risk than ones who are just going back to do things for their thesis.
Cool. I just want to make sure like we really use our time to get this actually settled and not like, have any outstanding questions. Elena, did you want to, I wanted to open up the floor to see if anyone wanted to squeeze in one more question, but I don't know if you had a different idea.
Yeah, we have like 3 minutes, so this one will have to be quick, but does anyone have any last minute questions? I see some people asking me if they can get some notes after. Yes, we will do that. Okay.
This is also
Oku.
Hoku, I see you're unmuted. Y'all not hear my question. Oh, I see. Hoku, sorry. I think Andrew is trying to clarify like, oh, but is it different based on the kind of type of work that you're doing? For example, if you, let me go, like you go into lab and you do an experiment for a collaborator, like at another university, which is like, I actually think that's a strategically bad thing to compromise, Andrew. I think that's actually the place where you should say, I'm not doing this work, but I think that's a strategy discussion. So if you choose to say, okay, I'm going to do this experiment to collaborate, right? I'm going to pipette some DNA, I'm going to work with some cells, I'm going to do that. Does that change your answer, Jonathan, about 50% FTE, 50% academic progress? Or they pay us 100%? Or Lee?
Doesn't change
I'm
my-
sorry, I'm not totally following this. So the idea would be he would be doing something. If you're doing it for, I guess the answer is I don't know. I didn't quite get the distinction being made there.
Yeah, I'm not really sure why it would be different than maintaining mouse colonies, Andrew, to do collaborative work.
Because maybe it's at a different university or something.
Yeah, like
Maybe that's
because is the argument that because it's collaborative, you wouldn't be able to say that it's academic progress? Andrew?
I think that's my fear really is I see students who are saying that they're only doing collaborative work, but not their thesis work. So don't worry about them not scabbing. But like they're really putting themselves at more risk by only doing the collaborative work, because that's more of a gray area than thesis work would be.
I see.
Okay.
That sounds logical to me, but I guess I'm still cautious about.
Yeah.
I agree that I actually think collaborative work, I don't know if it puts you at more risk. I agree that it could be maybe not academic progress if that's not what you're writing your final thesis on. But maybe also, Andrew, I would say that's a strategically backward analysis, because your PI would probably feel more impact and more embarrassed if their collaborator isn't getting any work done than if you're only making progress on your thesis. But I don't know, Lee, if you guys want to comment.
Oh, I'm sorry. I was reading something in the chat.
Yeah.
Could I'm sorry, I didn't hear your question.
Yeah, Andrew's basically saying some people are doing collaborative work, but I think that this is even riskier because it may not have anything to do with your thesis. And therefore you couldn't make the defense that it's academic progress. I feel like if you're doing work that is not related to your thesis, that would be more difficult to defend, though it also doesn't matter because it's not a PERB resolution, it's a university process one.
Yeah, it may be much too simplistic, Andrew and Alina K, but I don't know, I keep coming back to this sort of almost black and white thing that given the way these two things kind of overlap about student and employee and collaborative work, perhaps not working on your thesis, but it's still, if it still has aspects or resonance of academic work, it just, I just think it's going to be, and Andrew coupled that with people feeling more vulnerable about as a result of that. But I still think it's not that likely that the UC is going to go after people in those circumstances.
I mean, what would really happen is we file a cease and desist and the university would have to come to the defense of the PI, right?
And well, Jonathan said so many minutes ago, the university doesn't want PIs to be starting to decide who they want to discipline and who they want to mess with and who they want to, push out their own anti-union political views on. I don't think that helps the university.
I think keeping partial striking as a gray area is actually great for UC because it would suck if they had zero labor throughout all of this. I think partial striking sometimes is perhaps useful for the employer to keep as a gray area.
I have to go, I'm sorry, but let me just ask one thing. Is UC actually making these threats, or is this just people are worried about it?
No, it's just people are worried about it. No one has made these threats. People have been doing this for months. And I don't want to invalidate that. It is scary. And that's why I think we need to address it once and for all. But in practice, that has not happened.
Yeah, it seems like it hasn't. Yeah.
Goodbye, everybody. I gotta go.
Okay, thank you so much. We really appreciate it.
Jonathan, thank you. Thank you.
Okay, we'll talk, Mr.
Yeah, we'll talk.
Okay.
I got time this afternoon to talk when I take Kristen down to this dentist, this emergency dentist thing down. So.
All right, talk to you later.
Okay.
Thank you so much, y'all.
Is that the end of the conversation?
I think it's popping off.
Okay. Well, I guess if the vote's going on now, I guess it's all, going to happen. And, I just wish you folks, gosh, I just wish you the best. And
thanks. It's a stressful process that I hope, hopefully we'll get to some resolution soon that works for everyone.
Okay. Well, let us know if for any reason, or, the outcome or whatever there might be that we could, if there's something more or something.